Section 81 of Indian Evidence Act. Presumption as to gazettes, newspapers, private acts of parliament and other documents. The court shall presume the genuineness of every document purporting to be the London Gazette or any official gazette or the government gazette of any colony, dependence or possession of the British Crown, or to be a newspaper or journal, or to be a copy of a private act of parliament of the United Kingdom printed by the Queen's printer, and of every document purporting to be a document directed by any law to be kept by any person, if such document is kept substantially in the form required by law and is produced from proper custody. Section 81A. Presumption as to gazettes in electronic forms. The court shall presume the genuineness of every electronic record purporting to be the official gazette or purporting to be electronic record directed by any law to be kept by any person, if such electronic record is kept substantially in the form required by law and is produced from proper custody. Section 82. Presumption as to document admissible in England without proof of seal or signature. When any document is produced before any court purporting to be a document which, by the law in force for the time being in England or Ireland, would be admissible in proof of any particular in any court of justice in England or Ireland without proof of the seal, a stamp, a signature authenticating it, or of the judicial or official character claimed by the person by whom it purports to be signed, the court shall presume that such seal, stamp, or signature is genuine, and that the person signing it held at the time when he signed it the judicial or official character which he claims, and the document shall be admissible for the same purpose for which it would be admissible in England or Ireland. Section 83. Presumption as to maps or plans made by authority of government. The court shall presume that maps or plans purporting to be made by the authority of the central government or any state government were so made and are accurate, but maps or plans made for the purposes of any cause must be proved to be accurate. Section 84. Presumption as to collections of laws and reports of decisions. The court shall presume the genuineness of every book purporting to be printed or published under the authority of the government of any country and to contain any of the laws of that country, and of every book purporting to contain reports of decisions of the courts of such country. Section 85. Presumption as to powers of attorney. The court shall presume that every document purporting to be a power of attorney and to have been executed before and authenticated by a notary public or any court, judge, magistrate, Indian council or vice council or representative of the central government was so executed and authenticated. Section 85A. Presumption as to electronic agreements. The court shall presume that every electronic record purporting to be an agreement containing the electronic signature of the parties was so concluded by affixing the electronic signature of the parties. Section 85B. Presumption as to electronic records and electronic signatures. In any proceedings involving a secure electronic record, the court shall presume, unless contrary is proved, that the secure electronic record has not been altered since the specific point of time to which the secure status relates. In any proceedings involving secure electronic signature, the court shall presume, unless the contrary is proved, that the secure electronic signature is affixed by subscriber with the intention of signing or approving the electronic record. except in the case of a secure electronic record or a secure electronic signature. Nothing in this section shall create any presumption relating to authenticity and integrity of the electronic record or any electronic signature. Section 85C. Presumption as to electronic signature certificates. The court shall presume, unless contrary is proved, that the information listed in an electronic signature certificate is correct, except for information specified as subscriber information which has not been verified if the certificate was accepted by the subscriber. Section 86. Presumption as to certified copies of foreign judicial records. The court may presume that any document purporting to be a certified copy of any judicial record of any country not forming part of India or of Her Majesty's dominions is genuine and accurate if the document purports to be certified in any manner which is certified by any representative of the central government in or for such country to be the manner commonly in use in that country for the certification of copies of judicial records. An officer who, with respect to any territory or place not forming part of India or Her Majesty's dominions, is a political agent, therefore, as defined in Section 3, Clause 43 of the General Classes Act, shall, for the purpose of this section, be deemed to be a representative of the central government in and for the country comprising that territory or place. Section 87. Presumption as to books, maps, and charts. The court may presume that any book to which it may be referred for information on matters of public or general interest, and that any published map or chart, the statements of which are relevant facts and which is produced for its inspection, was written and published by the person and it at the time and place by whom or at which it purports to have been written or published. Section 88. Presumption as to telegraphic message. The court may presume that a message forwarded from a telegraph office to the person to whom such message purports to be addressed corresponds with a message delivered for transmission at the office from which the message purports to be sent, but the court shall not make any presumption as to the person by whom such message was delivered for transmission. Section 88A. Presumption as to electronic messages. The court may presume that an electronic message forwarded by the originator through an electronic mail server to the addressee to whom the message purports to be addressed corresponds with the message as fed into his computer for transmission, but the court shall not make any presumption as to the person by whom such message was sent. Explanation. For the purpose of this section, the expressions addressee and originator shall have the same meanings respectively assigned to them in classes B and JD of subsection 1 of section 2A of the Information Technology Act. Section 89. Presumption as to due execution etc. of documents not produced. The court shall presume that every document called for and not produced after notice to produce was attested, stamped, and executed in the manner required by law. Section 90. Presumption as to documents 30 years old. Where any document purporting or proved to be 30 years old is produced from any custody which the court in the particular case considers proper, the court may presume that the signature and every other part of such a document which purports to be in the handwriting of any particular person is in that person's handwriting, and in the case of a document executed or attested, that it was duly executed and attested by the persons by whom it purports to be executed and attested. Explanation. Documents are said to be in proper custody if they are in the place in which and under the care of the person with whom they would naturally be, but no custody is improper if it is proved to have had a legitimate origin or if the circumstances of the particular case are such as to render such an origin probable. This explanation applies also to section 81. Illustrations. A. A has been in possession of landed property for a long time. He produces from his custody deeds relating to the land, showing his titles to it. The custody is proper. B. A produces deeds relating to landed property of which he is the mortgagee. The mortgager is in possession. The custody is proper. C. A connection of B produces deeds relating to lands in B's possession which were deposited with him by B for safe custody. The custody is proper. Assuming that the document is more than 30 years old and comes from proper custody, there would be no presumption that contents of the same are true. Held in Mohinuddin versus President Municipal Committee, Khargone, 1993. Section 90A. Presumption as to electronic records 5 years old. Where any electronic record purporting or proved to be 5 years old is produced from any custody which the court in the particular case considers proper, the court may presume that the electronic signature which purports to be the electronic signature of any particular person was so affixed by him or any person authorized by him in this behalf. Explanation. Electronic records are said to be in proper custody if they are in the place in which and under the care of the person with whom they naturally be, but no custody is improper if it is proved to have had a legitimate origin or the circumstances of the particular case are such as to render such an origin probable. This explanation applies also to section 81A.